So, hello everyone. I'm Chloe Gibbs. I'm the Commercial Director of Shieldpay, and I'm delighted to chair this panel on a topic that is increasingly defining our sector, and that's what happens after a settlement or post-trial judgment when the challenge shifts from achieving redress to delivering damages or distribution of damages. So before I begin, I'd like to thank GLG for a great conference so far, for letting us have this discussion. And if I can also extend my thanks to Polly Blenkin of Milberg and Adrian Carr of Stephenson, Harwood. A couple of quick intros before we get started. So Polly began her career as a transactional lawyer, working on commercial real estate, debt securitisations, structured finance and restructuring deals at Paul Hastings. This was followed by over 5 years in Michigan's finance and banking disputes team, working on a broad range of financial industry and mis-selling litigation. In 2020, she left Michigan to found Milberg London. And in terms of casework, alongside a handful of other matters, Polly runs a consumer DPF claim against Jaguar Land Rover, where Milberg have been appointed as lead solicitors. She also manages Milberg's client care, operational and data management teams to support the firm's group action cases, and has overseen distribution of compensation to tens of thousands of Milberg clients. And if she wasn't busy enough, and if that doesn't impress you, she's also managed to play competitive football for the past 3 years with a ruptured ACL and doesn't know how. And she's also been an extra on Home and Away, so super interesting. And then Adrian Carr. So Adrian began his career in South Africa working on commercial and public interest litigation at Webber Wentzel's Linklaters, alliance partner. And after moving to the UK, Adrian spent nearly 2 years at HSF and just over a year at Charles Lyndon before joining Stephenson Harwood's group action and competition team in February of this year. Fun fact about Adrian, so he used to work or volunteer at a wildlife rehab centre, and when asked what the most terrifying creatures were, it was meerkats. He's also colourblind, so he didn't get the brief, unfortunately, today. And if his tie doesn't ever match his suit, he's open to audience feedback at the end. He's allowed me to say that. So going back to what we're going to be speaking about for the next 40 minutes or so, as legal professionals, we know that the public's memory of a case is shaped not just by the outcome, but how compensation is going to be delivered. So one of our anchor quotes for today, or for this session, is winning the case is only half the battle. Delivering justice is what the public remembers. So if I can jump into operational reality and essentially what happens when there's money to be distributed, we know that claimants expect swift, fair, transparent communication and payouts. And the expectation is, I've seen the headlines, the case has been won, I'm going to get compensation. And sometimes there is an expectation to that being delivered quickly after a long period of time. But the reality is, it is more complex. And we know that there are legacy payment systems that a lot of law firms have, and manual processes which can ultimately slow things down. High volume means more expectations and exceptions too. So people move away, unfortunately they pass away, they change their name because they've got married, or they require cross-border payments and so on. And there's a real hidden iceberg to distributing damages as a whole. And that includes hidden costs and lack of communication, which essentially erodes trust with claimants. And I think, you know, the difference between opt-in and opt-out, when we look at opt-in, it dramatically affects claimant engagement. So engagement can be high as 96% for an opt-in claim, but on the other end of the scale, for an opt-out claim, we're seeing, you know, very low percentages. So I want to open this up to Polly and Adrian, if I can. We want to learn about what's gone wrong, what's nearly gone wrong, what your experiences have been. And if I can start with at the end of a large legal battle, the new challenge becomes distributing damages to claimants. So what has your experience been? What are claimants' expectations, and are they realistic?
Shall I go first? So I think largely it's been a positive experience for me, because you've obviously had a successful outcome. You have money to pay to your clients. That is what we're all working towards on a daily basis. So that's always the starting point, that it's a great place to be in that situation. And I've run distribution exercises where I've interfaced with clients firsthand and seen what a difference it's made to people, like the money's come at the right time, or it's the difference between going on holiday or working over Christmas, all those kind of things, which has been really rewarding. I think in terms of the experience, probably the biggest learning curve for me was how long it takes to get through your whole book. As someone who works on the opt-in cases, GLOs primarily, whilst the first kind of 75% or so, you get them paid super quickly, and you've got lots of momentum, and it's really amazing how quickly, with a decent payment agent, you can get those funds out. 75% in the first 3 months, but then you could spend months, even years, trying to get through that last 25%. That was a really big learning curve, and I think some things we anticipated, other things we didn't. For example, how many people wanted checks in the post, vulnerable clients or elderly clients, those who just did not have online banking at all, then suddenly they're knocked into a different process, which as soon as you take it offline, that's very difficult to make things efficient and quick and cost effective as well. But I think overall, I've had a positive experience. We've been able to deliver meaningful payments, which I think has probably helped with the uptake. So, there's value there, people to get interested in it. But definitely that tail end and getting through that last 25% and pushing towards the 100 has been very challenging.
Thank you. And your experiences, Adrian?
I would say overall my experience has been largely similar to Polly's. Claimants are generally happy to have achieved a positive result, and now they want to go and see a tangible reward for their efforts. So it's understandable then that they want to get paid out as soon as possible. But at least initially, they may not understand the upfront effort that's required in order to ensure that a distribution ultimately pans out successfully. So what I've found is that administering a large-scale distribution is complex. It seems simple in principle. You pay out claimant X's sum to claimant X, claimant Y sum to claimant Y. But if you have a relatively simple process, that can quickly become unwieldy when you're dealing with thousands of claimants. So, do you have a plan in place to administer the distribution effectively and, of course, securely? This may include conducting some upfront checks to ensure that you deviate as little as possible from your happy path. For example, are you checking if companies are insolvent? Have they been dissolved? Things like that. Is it then cost effective for your legal team to go and administer the distribution? If you decide to engage a claims administrator, bear in mind that that takes time. Also, once they're engaged, you'll need to prepare proper instructions for them because they can't operate effectively otherwise. All of this takes time. Then you need to ensure that you've got appropriate systems in place to communicate with your claimants from the outset and throughout. That includes communications in respect of substantive developments, in respect of process, and any related queries. I think that the main risk of client dissatisfaction comes where they don't understand either the substantive process or the outcome. So clear communication is therefore required, and also an effective support system so that you can ensure the client queries are and difficulties are addressed adequately and promptly.
Yeah, completely agree. And I think going back to your point around the support system as well, because there are inevitably going to be unhappy paths. So you need to make sure that claimants understand why there is an exception, why they failed, if it's a faster payment transfer, why they failed a confirmation of payee check or a sanction screening, and you need to be able to offer that comfort to, you know, let them know that you're trying to get the damages in their hands as quickly as possible. Okay, great. So I'll move on to what works and best practice and managing the process well. So as we've just heard from Adrian and Polly, success does depend on planning before, but also during and after the process as well. So it does start ultimately with stakeholder alignment and claimant education, to be followed by clear timelines, transparent communication, robust audit trails, and expectations do need to be managed at every level. But we also know that there is regulatory scrutiny over things like residual balances, which also need to be planned for and accounted for. So we've discussed in our planning sessions utilising automation to enhance those processes and how they play a key role in building trust, not just amongst the sector, but with the public too. But also operational efficiency and reducing risk and hidden costs and administrative burden internally too, because as we scale up as an industry, we need to, you know, make sure that we are implementing and leveraging technology as much as possible to support the scale of growth. So the role of data, communication, collaboration is key for opt-out claim readiness, and we've discussed that, and early and ongoing communication too. So we've also touched upon, and if I can get your thoughts on this, the collaboration with defendants or defendant firms to help access claimant data. So that may require court mandates and can be resisted, and which poses challenges. But ultimately, what we're trying to do is reduce claimant effort as much as possible to build higher engagement rates. So interested to get your thoughts on how you manage expectations across stakeholders from funders to claimants, and what risks do you think exist or that you know exist, how you manage them, and ideas or speculation to make it easier for claimants to engage and trust our system.
Yeah, so I mean, in terms of managing claimant expectations, I think that is a dialogue that should start as early as possible, but there's obviously a little bit of a tension without, you know, you can't guarantee outcomes, you don't want to give unrealistic expectations, and so there's a line to be walked in terms of how much you can really engage with your clients about distribution before there's a prospect of distribution, whether that's coming closer to trial or being you know, at the steps of court, or whether settlement discussions, negotiations are happening, often confidential, and often very sensitive. You don't necessarily want to go and be telling thousands of people that you're having conversations. So you can talk about things in the abstract from early on. Obviously, if there are precedents in the market, that's really helpful. You know, if you look at the kind of PANOX litigation that's in trial at the moment, you've got the successful outcome of the VW GLO that happened in 2022, which there's generally a lot of awareness around. That's kind of a helpful context for those clients without you actually having to properly engage with them. But I think as soon as you can start to talk more meaningfully about what happens if and when money comes in, then that's always going to be a positive thing. And I think that can often be a judgment call depending on the size of your book and how you know, how funds are being allocated, whether there are different groups receiving different amounts, whether you're going to try stagger payments. So if you've got a huge book of 100,000 people, are you going to tell everybody at once that you've got some money to pay, or are you going to do that in a more managed way, which means that, you know, people are not, you know, someone who doesn't get paid at month 6 hasn't known for 6 months. Yeah. You've got much closer to when you can pay them and manage that properly. So that all needs to be kind of thought about. But I mean, simply put, I think clients have an expectation that if you've had a successful outcome, they have been waiting a long time for that. We all know group litigation isn't a quick process, and they justifiably want to know how much and when they can have it in their bank account. I think that's a fair expectation, and I think for the most part, as I said at the beginning, kind of 75% of people you can pay very quickly. And I think most people are very, broadly happy with the process. It's managing that tail end, and as Adrian said, explaining why there's a hold-up and having that kind of dialogue. Expectations in terms of internal stakeholders as well. I think there's a lot of different kind of components to making a distribution exercise successful. You've got your legal case team. They're the ones that understand, how the funds might be allocated amongst the different claimant groups, and they've obviously negotiated the settlement, and they'll probably have steerage of the exercise generally. But then you've got your data team, your ops team, your client care team, your compliance team, your tech team. All of those moving pieces need to be working together and in harmony to make sure that you've got a compliant, cost-effective, efficient system that's working as it should. So, talking to everyone all the time is important in managing those expectations.
Yeah, I would certainly echo that. I think process in particular is a very important point for managing expectations. Claimants don't like surprises. So if you've got a complex or unfamiliar claiming process, that can create barriers to uptake. So if possible, you want to explain this process as simple as possible upfront, how it's going to work, identify what information and documentation claimants may need to provide. This can also help you identify potential issues and avoid frustration and delay down the line. Also, early management with internal stakeholders, I agree, is important. That can help ensure that any processes and requests are respectively streamlined and necessary. You might have some stakeholders as well that are a bit more risk averse, and they may want to have, say, strict verification requirements in place. But you've got to bear in mind that a balance is to be struck. Distribution mechanisms, they need to be practical and claimant-friendly without being so onerous that you have verification requirements that deter participation. Now, when it comes to building trust and engagement, I'd say that this isn't really an issue so much with the multi-party litigation as it is more with group action or as with opt-outs or collective proceedings. And now there, if you get a low uptake rate, that is a risk to the regime in that it undermines the dual objectives of deterrence and compensation. So how do you go about managing that risk and make it easier for claimants to engage with the system and trust that it actually works? I think one potential option is that you begin the process of class identification at a much earlier stage in the litigation life cycle, because at the moment we've got the clock starting to tick at the distribution stage. So that's only after settlement or judgment, which creates a short, intense window in which you need to identify class members, verify eligibility, secure participation. So if you began these efforts much earlier and ran them in parallel with the substantive litigation, that would help build a more engaged class by the time you get to distribution. And I think in that regard as well, technological solutions, including having a secure digital claims platform, targeted advertising through channels that class members actually use, those are going to be essential to promoting engagement. And then also you shouldn't be averse to innovation. We know last year from the CAT's judgment in Spottiswoode that there's considerable scope for creativity in distributions. And the CAT's going to expect to see such creativity in the proposals that are put before it. They need to see that there will be a real benefit for the class at the end of the day. Now, what may work in terms of distribution processes will depend on the facts of the particular case that you're dealing with. But for example, you may have account credits that are appropriate in the circumstances. That may help build that actual payout will help build trust in the system. So you've got to go and make sure that the distribution process is planned out and appropriate for the facts of the case that you're working with.
Do you think it's a combination of those three things? I'm just trying to think about what's the main issue with low uptake on those kind of cases. We haven't seen many at all, but is it lack of awareness? Is it there are issues with the verification process, or is it it's something to do with the quantum and the value of payouts? Do you think one is more important than another?
Well, I think in general, what we know from other jurisdictions is that low uptake in opt-out proceedings is not something that's unique to the UK. It's seen in Canada, the US, Australia. So the fact that there's low uptake here shouldn't come as a particularly large surprise. The goal of a distribution and opt-out proceeding shouldn't be 100% take-up. You're never going to, or you're very unlikely to be able to achieve that. Rather, you want to have by and large, effective distribution to the benefit of the class. Barriers to participation, it's a relatively novel regime in this jurisdiction. You've had one distribution, really.
Yeah.
And that particular case, there are certain facts of it that may have contributed to a lower uptake. For example, the time passed since the relevant claim period. But the low uptake, I don't think, should be used as an argument that the regime is not, or doesn't have the potential to work. There's also a deterrent effect that can be brought about by having a damages award that's granted or a settlement that's been achieved, and that in and of itself is a benefit to benefit to class members potentially.
Yeah, definitely.
But yeah, I mean, so unfamiliarity with the regime, complicated claims processes, and general aversion to participating in a distribution process where people may be concerned about providing personal information for risk of being scammed. I think those present barriers to a successful distribution.
Yeah, and that's something we've experienced in the opt-in regime as well. And as in people's kind of skepticism about your request for details or receiving a link. And that's even in circumstances where we've been communicating with them for years, and they've instructed us, and they know the Milberg name, etc. And there's still that level of skepticism. So obviously that is that's another a whole other challenge in the opt-out, where you haven't got that kind of relationship with your clients already. Yeah.
As the regime develops, I'm sure that that situation will improve. But when you're at this very initial stage where there's so few examples, people are unfamiliar with how things work, it may be hard to win them over.
Yeah.
Yeah, and just to add to that, I mean, if we look at boundary fares as an example, if consumers had a choice, they were receiving backs payments, I believe, by way of distribution. If there was hyper-personalisation and there was other methods of distribution available, be that vouchers, train tickets or whatever, then would more people come forward? Because I think if we look at the Department of Business and Trade's review around meaningful distribution or meaningful value, as a payments expert, loosely say that, but as a payments expert, I would say that we should be measuring meaningfulness by way of how easily accessible damages are. But if you are looking at relatively low values in the tens or hundreds, then should there be multiple choice available to the consumers to incentivise them to come forward? Because what if somebody didn't want to receive that money into an overdrawn bank account, as an example? Or what if you've got somebody that £40-50 is worth, it's relative, it might be a lot of money to an individual. So I think that there's definitely more consideration to be had at that scale. Okay, I'll move on because we're short on time, but the regulatory landscape, it's shifting. Get words back in your mouth. So the SRA is consulting on whether firms should hold client money at all. We've seen the Department of Business and Trade reviewing the opt-out regime to balance redress and administrative burden or business burden. And the SRA's thematic review on residual balances, client onboarding, it's all under scrutiny. So as these claims scale up, so do the challenges. Managing residual balances and unclaimed funds is kind of at the top of the list, I feel, for this year. Even the smallest of percentages of unclaimed funds could mean that millions is left in limbo. So the role of TPMAs and digital solutions, that's growing. But with this, providers, they have to ensure that robust processes are in place to support the regulatory landscape. So my question to you is are firms ready for the next wave of mega claims being class actions, and what does need to change?
I think yes. I mean, everyone I speak to, the firms that we work with on our cases, distribution is on everybody's agenda. I think there have been a lot of learnings the last few years, and I think everybody recognises that it's in the market's interest to get the distribution process working as well as it can, with technology and the right partners. And also just, sharing ideas and experiences. How did you deal with that? How have you ever had this? I've had those conversations with my peers at other firms, and something useful always pops out. And I think I think people are ready. People are thinking about it. Certainly, if I look back at when we first started Milberg at London, it just seemed so kind of abstract. We were just starting, but now right from the kind of the get-go in terms of originating cases and working out what your book size is going to be. Immediately the cogs are turning in terms of what that will look like in a successful outcome and distribution. And certainly internally, I'm always kind of banging the distribution drum with all the cases to be like, you need to think about it. Don't be reactive. There's as I said earlier, there's only so much you can do in terms of client interface or other steps. You can't. There's a limit to what you can do. But there is also just a lot of thinking and stress testing different processes, different partners, different solutions for the same issue that is difficult to bring together. So I think people are thinking about it, and I think. The claimant firms certainly that we work with are ready, for sure.
Yeah. Adrian?
Yeah, I completely agree that we're well and ready for the next wave of claims. I do think that it will be essential for those that distribution is seen as an ongoing process rather than an afterthought. That'll help you achieve some successful distributions and, more importantly, help ensure that the interests of the class, in the case of opt-out proceedings, are actually promoted, because ultimately they're the ones that will benefit from successful distributions. When it comes to then changes to the regulatory landscape, I know that there's been some talk about firms potentially no longer holding client accounts. Yeah. I'm rather agnostic on how things will develop in that regard. I don't think that having, say, for example, a third-party managed account is going to reduce your risk of being exposed to money laundering. You're still dealing with the same transactions, still providing facilitating the same transactions, still providing the same advice. Maybe circumstances where you would benefit from having a TPMA. You can have your funds ring-fenced. You'll benefit from the standards of protection afforded to or abided by an FCA-regulated entity. You also have some real-time assessment of the funds that are being held in that particular account, but I don't think that there'll be much benefit in having that as the sole system rather than allowing firms to continue to operate their existing client accounts. Have the relevant checks in place on your client accounts that'll help you avoid risks of money laundering and whatnot.
Yeah. Okay. And what about residual balances?
Yeah, well, with the residual balances, so this is a potential issue when you have large-scale claims. So just by way of background, just generally, currently I believe it's if you have balances under £500 where you're not allowed to, where you can't go and track your client, then you may go and pay those out to a charity. If the balances are in excess of £500, you'll need to get SRA authorization in order to deal with those funds. Now, is there scope to rely on the SRA increasing the value of the £500 limit so that you can have a bit more scope on how to deal with residual balances? Probably not. So what you should go and do is then avoid the risk that may be posed by having large residual balances in your client's account. So what you go and do, you go and strengthen your record keeping, make sure that your financial records are up to date, track your various transactions, proactively contact your clients, ensure that their contact details are up to date so that you don't have them in extended periods of time whereby you can't reach them and can't ultimately pay out funds that you may have hold on their behalf. And if things don't work out as well, you should go and preempt that possibility by having a residual fund policy in place so that you know what to do in the unfortunate event that you aren't able to locate a client. Have those principles in place, and you should be able to go and deal with the tail end.
So it goes back to effective communication with your claimants. It kind of all comes back to that. The trust and making the distribution successful. That is also true of residual balances. The more engagement you have with your clients, the more likely they are to update you when they move, to respond to your emails, to take their spam filter off, all those kind of things. I mean, it would be interesting to see if the SRA does take more of an interest in residual balances, particularly for group litigations, because as you say, you can have, by any measure, a very successful distribution exercise where your uptake is in the high 90s of percentage. But if you've got a huge group and you did well on damages, then in isolation, saying that you've got 2,000 residual balances and these are just hypothetical numbers, or millions sitting in your client account, then in isolation, those look quite alarming. In certain contexts, I think. So, the SRA is looking at this at the high volume market generally. It'd be interesting to see if they do look at that, or whether actually, a couple more years of cases and distributions coming through, they realise that actually they need to update their processes. I agree it's unlikely they'll change the rules. That £500 threshold, I can't see that moving anytime soon. But they might be able to do something with their processes. So, their application form, considering those en masse, whether or not they'll reconsider the steps that firms need to take before they'll accept an application. I mean, one difficult thing to judge in the tail end of a distribution is when you make the application to the DWP for using their tracing service, the Department of Pensions, Workers and Pensions. That's an SRA requirement to do before you make that application to withdraw from the client account, but it's pretty expensive. It's over £4 per trace. And there's currently a 10-month backlog. So it's not quick, and it's expensive, depending on how many clients you're looking at. So there's a judgment there. So, I've got 20,000 clients. Do I send those all to the DWP now? That's going to cost X amount. And this is at a time where you've already taken your fees. Have you planned for that properly? Have you got the budget? Where's that money coming from? That's kind of challenging. So, I would hope in the next few years there is a productive dialogue with the SRA about how all of those things can be made to be, I guess, easier or more efficient, because I think it can very quickly become uneconomical and difficult to execute all of that.
Yeah, I agree. I think there needs to be a bit more clarity around that process. And I guess it's another shameless plug, but another benefit of using a TPMA that has got residual balances policies in place. So obviously if you do use a TPMA, it's FCA regulated, so it's governed under those rules so that funds can move into an unallocated pot, if you like, and then a TPMA can hold on to those for, I think it's up to 6 years by FCA obligations. And if a claimant was to come forward and ask for their compensation or their damages, that can be released to them. So there is that longer time period for them to come forward. But thank you, that's really interesting comments. So we touched upon claimant expectations and how they're evolving and choice and the DBT review. And I think a quote that Adrian said earlier, which I absolutely love you for, is distribution can't be an afterthought. It does need to be planned throughout the life of proceeding. So in our final minutes, this has gone super quick, but if I can ask you both to crystal gaze into the future, the next couple of years, and what best practice looks like now and how firms can prepare for more and future scrutiny, as we should expect, and essentially how we can be more proactive from the earliest stage, so that distribution is a priority in each case team.
We should all win as many cases as possible. So there's lots more distributions and there's more learnings. Because I personally learned a huge amount from doing my first distribution. It was a big learning curve. And so the more successful outcomes that we have, the more distributions that we have, that will require the market to engage with it, and awareness will grow, trust will grow, all of that stuff. But I think technology is key, but I think there's also there shouldn't be an expectation that technology can solve it, because you're dealing with humans at the end of the day. And whether it's someone in their 80s who doesn't know how to log on is at the end of the phone and she needs you to chat through it and then write her a check, you should do that.
Yeah.
You should do that. It's so I think there's technology is a great asset, and I think the technology, even in the time that I've been doing distribution, has improved immeasurably, and more kind of interfacing between a law firm's systems and processes and a payment agent. I think that's all really, really important. But it's more just kind of knowledge sharing, I think, and that is also just within firms as well, understanding and having the appetite to learn about this aspect of a group litigation case. It doesn't end when you get the win or when you sign a settlement agreement. It's like a long road in terms of making sure that money gets into the hands of the right people, and everyone should be interested and invested in that process.
Yeah, definitely. And I think, just touching upon your point before I get your comments, Adrian, as much as we should look forward, we should also recognise the past as well. So we have worked with groups where they're not comfortable giving their details online. So we've been able to accept details through the post, as an example, or by telephone. And there's a whole load of work that goes into that process that I think perhaps sometimes firms don't consider. So yeah, planning is absolutely essential. So Adrian, can I get your comments?
I see. Yeah, the time is running out here, so I'll try to be quick.
19 seconds.
Yeah, go.
Yeah, distribution, it's a reputationally sensitive moment. So if you've got a poorly run distribution, that can undermine the legitimacy of your litigation, even if your legal result is sound. So if you've got claimants that do not understand the process, they feel excluded, they feel that that stakeholders other than them have benefited disproportionately, that can undermine their confidence in the system and the process. So communication throughout, just be clear what outcome has been achieved, what they're entitled to, how they can participate in the distribution process, work closely with the relevant third parties to ensure that you're all communicating consistently and effectively, so that you can promote engagement throughout.
Lovely, thank you. I don't know if we've got time for questions, if anybody's got any. No, we won't sing for you either. No, all good. Well, thank you very much for your time.
Thank you.
Thank you.
Thank you.